beautiful friends. So I went a little bit rogue today. I'm going a little bit rogue today. I told the girls I got hung up in the Kohberger hearing. So y'all know the Karen Reed trial is killing me. Killing me. Killing me softly. I love that song. Anyway. So we're switching lanes today, and we're going to watch the Kohberger hearing. It just ended. Well, actually, I don't know if we'll be able to catch anything that's going on after the fact. Let me look real quick. Because they do go on a break, but they do. Oh my gosh, Laura, hey! Hi, good to see you. Hello. Hey, Sherry Jones. Hey, Brenda. Good to see you guys. Laura, it's so good to see you. It's been a minute. How are you, dearie? She's like, I saw the word Bryan Kohberger and I'm here. So yeah, like I said, I'm going rogue today, you guys. For those of you that are on the Karen Reed bandwagon, Morgana, I'm so sorry. I'm so sorry. I just had to go a little bit off topic for today. So, this is the last Bryan Kohberger hearing. So, anyway, I will say it is not fireworks and all that jazz, but it is full of all the details. And for the folks that are detail-oriented people like myself, we're getting dates and times and information for how Judge Hippler expects this trial to go. I love this man. So, a little switch up, right, Brenda? I know. I like to switch things up every once in a while. But honestly, I told the girls, I'm like, because I'm not going to be here tomorrow, I'm not going to be streaming tomorrow. If you missed that, I mentioned it yesterday in the stream that I won't be streaming tomorrow because Kiddo has 2 doctor's appointments tomorrow that have been scheduled for a while. So, nothing crazy. She's fine. It's just little visits that we've had scheduled for a while. One for the eye doctor and one for an endocrinologist. So that's it. But I won't be streaming tomorrow. And also on Wednesday, the following week, on I think it's the 21st, I won't be streaming either because it's her kindergarten graduation. So yay! Yeah, I will not be streaming on that day. Sorry. I had to grab a paper towel. I got a little bit of my nose is running. My nose is trying to run. Stop it. I got Kleenexes somewhere. So yeah, I won't be streaming tomorrow or Wednesday. And I'm like, okay, so if I'm not going to be streaming on those 2 days, it's not going to hurt to go rogue today either, right? Hey, Aurelia, good to see you too. It's been a minute. I've missed you. I can definitely tell who the non-Karen Reed people are, Aurelia and Laura. They're like, yeah, nah. Done saw it once, don't need to see it again. So anyway, we're going to watch this hearing. And we will probably speed through a little bit of it, like 1.25 some of it. Not a fan of hers. Well, I mean, I'm not going to say I'm not a fan. I'm not going to say I'm a fan of hers per se, but I do have my feelings regarding that case. Most of y'all know. But anyway. It's just a little cattywampus. So is my nose today. What in the world? All right, so we're going to get started with this. And, yeah. Did you guys happen to watch the Dateline special that came out about Kohberger, Idaho 4, a few days, like Friday of last week? If anybody watched the Dateline special, put your hand in the air in an emoji, or just say me or something in the chat to let me know. Brenda, it's so good. It's so good. Aurelia says, I do too. You know, when the radio would play your favorite song 24/7 and at some point you just get tired of it? That's where I'm at with Karen Reed. Well, same. I mean, don't get me wrong. If Michael Proctor ends up on the stand, I will watch that. If Brian Higgins gets on the stand, I will watch that. I will watch those. But like today, the medical examiner was on. And I usually love that stuff, but I've already heard it once. And, you know, so I'm just over it at this point. Gosh, my nose. And it's just this one side. I need to go use my Flonase. I'm not great about using my Flonase in the mornings. I take my Zyrtec at night, but I forget my Flonase in the mornings. Oh, well. So, Brenda, it's really, really good. You should be able to find it on Peacock. It's so good. And there's some stuff in there, you guys, that you didn't watch it either, Laura? Oof, I want to do a video about all of the things that they mentioned in there that we have not already heard. There was a lot of details that was mentioned that we have not already, and like new selfies of Bryan Kohberger, and yeah. Hey, Donnie. Hey, Margaret. Yeah, Donnie, you'll have to rewind. I've only been live for like 10 minutes, less than if you count the intro. But anyway, you'll have to rewind and listen to my reasoning for why I skipped Karen Reed today. Donnie is not a fan of the Karen Reed trial either right now. So, you guys, I bought some mousse. I've been trying because nobody's mentioned this either. Let me just say, hold on a minute. Just hold on a minute. Now take a look. Look. I have cut my hair. Like it was way long, right? I have cut my whole hair. Because my mic's way up here. I cut my hair off. It's just below my shoulders. I did it myself with that thing. I forget his name. Where you do the butterfly thing that you can do yourself at home. I did it myself again. I did it a long time ago, but then I did it again because I wanted to go shorter. I did this before I went to the retreat, and nobody's noticed it. Nobody said anything. But today, I cut my hair, and it's put some layers in it, right? And, I was like, because it was like curly one day. It's because of the layers, right? So, you noticed at the retreat, Brenda? But yeah, I'm like, let me get some mousse and see if I can get this stuff to scrunch up a little bit, So, yeah. It's more of a wave than a good curl, but it is what it is. My hair is typically like flatter than I don't know, flatter than a pancake, I'll say that. Oh, I did, Sherry? Well, I had a little bit of mom juice, not much, but I forget. Margaret, I know the Karen Reed trial is a snooze fest right now. I know. Flatter than a pancake. Brenda, around here we say something else, but we say flatter than a flitter. But anyway, okay. So here we go. I'm going to hit the play button and we're going to get started. Let me put this back up. And Brenda, it won't make sense to probably none of you because around here that word means something totally not it. I don't know. It's a word that we use, especially around here. Most people know what it is when we say that, but other people are like, I don't know what that means, but okay. So it describes a certain body part for a woman, but anyhow. All right. And I don't know what that has to do with being flat, but anyway. Were you catching up on the Nova Scotia kids too? Yeah. I was watching something this morning, Donnie, and yeah, I've been saying this for the past few days. I really want to get and do some streams about those kids. I mean, and of course, Kohberger and Stearns and, all the things. Strange stuff going on with that case, Donnie. I know. What do you think? What's your theory? All right, we're going to hit the play button and get started. Here we go. Here we
State
go.
v. Kohberger, the defendant and counsel for both.
Just a heads up, too, the audio is all the way up. So if you can't hear it well, you may need to use, I almost said hearing aids, Margaret. You may need to use hearing aids or AirPods or headphones or something of the like. Okay? Okay.
Both sides previously identified are present. We are in the public session now. I have my own agenda for what to cover today in the pretrial motion, and so I'm not sure what you have. I didn't receive any specific motions to cover today other than, I think, the ones previously submitted by defense related to questioning of the jury. As I indicated, I don't
No.
intend to discuss in the public forum what specific questions would be asked of potential jurors, because I think that inhibits the ability to get frank and unprepared answers from potential jurors. And so we may have to cover part of that in a session at the end of the day. I think we can talk about it generally without discussing the specifics, but if we need to go there, that's what we will do. Apart from that issue, as what I intend to do is kind of break down the trial process through stages. And as you have issues or questions about whether how to handle something or how the court handles something, that's your opportunity to ask as it relates to that phase of the case. And we'll just sort of proceed in that fashion. So starting with some general issues, I just wanted, and a lot of this is unfortunately going to sound like me simply lecturing about what I want and don't want. And that certainly is a large part of it, because if you know what I expect, I think it makes your job easier. And so I, particularly where I can't recall whether Ms. Massoff has had any trials with me or not, but I know she's been in front of me a few times, but the rest of you have not. And so it's, I think, important that you get that information straight from me rather than from the sources that you may get from asking around. So to start with, I'm not a fan of surprises, as you may have figured out by now. I want to know in advance, as far as possible, when there are issues that need to be addressed. That includes evidentiary issues. So if you know that you're going to object to some line of evidence, or you anticipate that there's going to be objections to a line of evidence, I don't want to wait until that is offered in the middle of trial for a couple reasons. One, I don't have the opportunity to look at the issue to the degree that I would want to in order to give you the best ruling that I can. And two, it doesn't give you the opportunity to make the best case for me that you can for either excluding or overruling any objection. And perhaps even more important than all of that, from my perspective, is in what is already going to be an quite lengthy trial, it just extends it. And nothing frustrates jurors more than sitting around in the juror room doing nothing while we're in here doing something. And so that helps guard against that and minimize that amount of downtime that we may have. So we'll have periods, as I will explain to you, before court each day and after court each day, where if you are anticipating issues that are coming up, that's the time to talk about that, not in the middle of the trial itself. I did receive the parties' stipulation regarding how to handle the IgG tip, if you will. I'm fine with that proposed instruction, and so that will be given. I think I'd asked you also to work on instruction related to the use of the terms surrounding touch DNA and other variations about that in the event that I decide to correct somebody about the use of that term. As I said, with respect to the professionals in the DNA community itself, I'm not going to prohibit it in the sense that, you know, I'm going to sustain an objection. What I would likely do is to clarify with the jury, if the parties want me to, about that being simply a convenient title and not meaning to imply an actual source of or method of the DNA being present.
That's
so
a surprise,
if you haven't worked on
right?
that, please do so to get me an instruction you both can live with. Otherwise, I'll end up drafting one myself, and perhaps neither of you want to live with it. So, with respect to the model, I think referred to as the dollhouse by Mr. Thompson, has that been produced for the defense to inspect?
It has, Your Honor. It's actually here in this courthouse, has been for a few weeks, and Mr. Hurwood facilitated the defense of viewing it yesterday.
Okay.
It is available for the court's inspection well if the court would like to look at it. And just for the record, to the extent that the model was characterized as a dollhouse, I think that was an inappropriate characterization. It is an inappropriate characterization. If I'm responsible for it, I assume responsibility, but that's simply not an appropriate way for it to be described given what occurred there and the victims.
I think a better term is simply a model,
Yes, sir.
rough model, given that it is admittedly not to scale precisely. So, Ms. Taylor, any record about that? You had a chance to look at it?
Your Honor, we did. We were able to bring 2 experts in for our request yesterday, and we appreciated being accommodated while we were here. We do have a remaining question about where the model house will be stored during the course of trial.
Where are you storing it, on the 3rd floor?
Yes, sir.
Okay. So it sounds like it's stored with the evidence vault of the prosecutors down there. And so I suppose if she needs to get access, or our experts do, we can arrange for that as well.
I should have asked a better question, Your Honor. When it's brought in
Oh, I
as a
see.
demonstrative aid, I'm curious about when it's not being used by the prosecutor or the defense and a witness, where it will sit in the courtroom.
I will find some place not in the courtroom, because I don't want it in the courtroom when it's not being used, but nearby in the event that a witness does wish to use it.
Thank you, sir.
Interesting. I wonder how big that house is, that 3D model. I wonder how big it is. Has anybody heard? How big
The other
that
thing
is?
that I would point out, as, it sounds like you've been at least to some degree working together, and I appreciate that. As you come to stipulations on things, agreement on things, it's important that those be reduced to writing for your own protection. Because too often what I see is in the middle of, for example, trial, well, Honor, the other side said that they were going to stipulate to that, and then they're not. That leaves me in a difficult position because I wasn't part of those discussions, right? And so for your own protection, I think it's just important that you get those reduced to writing as much as possible. I did receive the parties' spreadsheets on the exhibits, which we'll go into a little more when we get to the exhibits portion of today's menu. But I appreciate getting that. There's some questions that I had about it generally, and then some more homework to do on it. In terms of the witnesses, I had asked, and I think my law clerk reached out to make sure that we get a description of those witnesses, kind of like if they're, who they work for or where they're from, something that will allow me to categorize those on a juror questionnaire so that they don't just get a list of, 300 names, but can say, all right, these are witnesses, these people live in Pennsylvania. These are witnesses that work for the FBI, right? And so that they can put in context those names, which will be result in a more accurate review by them of those names to see if they know anybody. And I'm not sure if that's been accomplished yet or not. And so if you haven't done that, please get that to us as soon as possible so we can incorporate those. I think the state had, and last I had heard, but it's been several days, the defense had, we were still waiting for someone from the defense.
And I believe that that's been provided. My hope is that it was sufficient because I think it came back and we re-provided it.
Okay, I'll check.
If it's not sufficient, let us know.
I'll check on a break to see where it's at. All right. So I did, as I indicated this morning, receive the defense's proffer regarding alternate perpetrators. That will be sealed per request, I'm assuming per stipulation. I want some additional.
Give me
the
names.
23rd, if possible, for the defense to do two things. One, provide me with whatever actual evidence you have that supports those allegations, rather than just allegations. And two, provide for me how it is you believe that what you are offering is admissible. Because it seemed to me much of what you had put in there was fairly potentially fairly objectionable in terms of admissibility. So I would like to see that. And then I would have the state respond by the 6th, which is 2 weeks. And then I would propose a hearing on the 18th.
Yeah, and that will not be public, I'm sure. They're not going to show that hearing. I would assume. I think that they mentioned that that's not going to be a public hearing.
Ms. Nassau has a conflict in the morning, but we could do an afternoon hearing on that day.
Can we do the 20th? The 19th is a holiday, and the court is closed. I'm just not sure whether it can be done in a half a day or in the afternoon or not, depending upon where we're at, is my concern.
Your Honor, for me personally, the 20th is a little bit of an issue for personal reasons, if we could avoid that date. If we can't, then I guess we can't.
Well, let's, can we start by like noon on the 18th?
12:30 or 1. I'm in federal court.
All right, let's do 12:30. Are you handling those issues?
Alternate perpetrator. I'm, yes, very involved.
Let's do 12:30 on the 18th. All right, next I want to go to juror questionnaire discussion. Before I do that, this was that was, as I said, sort of a catch-all category. So I want to ask if you have questions now, because I suspect it will fit into, if you do, a more specific category, and we can address it at that point. But if you have a question or concern about anything we've talked about thus far, now's your chance.
I believe so, Your Honor.
No, Your Honor, thank you.
All right, juror questionnaires.
No, it looks frozen. Hold on.
Counsel and the defendant, when the questionnaires are the right to be present.
Okay.
But when the questionnaires are administered, but I suggested to you that perhaps your time is better spent in reviewing the questionnaires than watching people fill them out. The process will be such that as we bring groups in to fill those out, those will immediately be scanned and then provided to counsel on a shared drive. And so I guess I wanted to get your feedback on whether I suspect this is a all for one or not proposition.
Thank you, Your Honor. My understanding is we have both agreed that there's no need for counsel from either side to be present during that stage. We'll focus on the tasks at hand.
Okay, very well. Does that accord, Ms. Taylor?
Please, Your Honor.
All right, very well.
Hey, Susan. How are you, dearie?
So as I indicated, you'll be given access via shared drive. You can do two things. One, you could save those over to a copy over to a drive in which you can make edits, or you can print and make hand edits, or you can just keep track by notebook and juror number. If you want to do the printed version, you'll need to bring your own printer and supplies in order to print those off from your war rooms. The plan will be to take the universe of jurors who are summoned and then scramble them randomly and assign them what we call a scramble number, 1 through 10,000. And then we will bring them in to fill out the questionnaires beginning with 1. So that the questionnaires that you receive first will be the jurors most likely to be in the line of fire, so to speak. Because once we have enough jurors, we'll stop. So that's the plan. Anybody have any concern with that?
No, sir.
No concerns, thank you.
Technically, under the rules, you are entitled to watch the scramble process, which literally involves the jury commissioner hitting a button. I don't know if any of you want to be there for that.
No, thank you.
We'll waive our presence tonight, Your Honor.
Very well. I do want to stress the security and confidentiality of the juror questionnaires. As I'm sure you're aware, pursuant to Criminal Rule 23, those are extraordinarily confidential. The copies that you receive will be, we'll maintain a copy, obviously, for appellate purposes, but the copies you receive will be returned. And the defendants, they're supposed to be essentially attorney's eyes only. I'm fine if you both agree to allow an investigator to see, so that they can be doing, whatever online investigation they feel appropriate as you go along. Doing that, in terms of the defendant, his access has to be with attorneys present. In other words, he can't have a copy or whatever to go back with him when he's not with you.
That makes sense, but I have one question for
Sure.
the court. In addition to our investigators, we have 3 that are working on the case. We would request our paralegals be allowed to assist us. Just with the magnitude of the task, we'd like to have the assistance of our paralegals in organizing and reviewing.
Sure.
And likewise, Judge, we would hope to use our administrative assistants in the process, and they are part of our staff.
Sure, and by court and bar rules, you're responsible for their conduct, and so you'll need to make sure they understand the confidentiality of those questionnaires, and it's really your ticket on the line for their behavior. So that's fine. But I do want to stress that confidentiality because it is part of what I'm giving the jurors on the instructions, is letting them know that there's very limited number of eyes that will review this and that the public never will. So. The plan will be to try to process the first questionnaires. As I said, you'll get them each day and go through them. After 3 or 4 days, we will start to have hearings. Those will be sealed hearings because we'll be going over the questionnaires in detail, in which you folks identify the concerns you have with the questionnaire answers, specifically whether there's a motion or agreement to strike a particular juror before we ever have to bring them in based upon the questionnaire answer, right? And the idea is to dismiss those who are unlikely to be put on the jury because of either perceived bias, knowledge of the case, or hardship. And so, I think it helps everybody if we are trying to agree to that as much as possible. It's the reason that we are summoning as many people that we are, is so that we can really cut through the chaff and get to the wheat. Any questions about the juror questionnaire process?
Sir.
So the next topic I have is voir dire, more specifically. Traditionally, the way, as you know, voir dire works in Idaho is the court first does its voir dire, touching on some essentially statutory kinds of bias or knowledge. And then counsel is given that opportunity. And so much of what would be the court's voir dire, I have incorporated into the questionnaire so as to limit my role in actively questioning the jurors or potential jurors. I may follow up on some of the answers given on the questionnaires if I feel there's a need to. But otherwise, the time will be yours. What I intend to do, and I'll get your input on that, is using a model very similar to the model Judge Boyce and I came up with in the Daybell case, bringing in groups of anywhere from 15 to 20 people at a time, having a general session of questioning by the attorneys, approximately 30 minutes aside of those folks, get through challenges for cause or dismissals for hardship, et cetera, of those folks. And then who's ever left over of that group then would be subject to individual questioning by the attorneys. And so the jurors that are left over will be taken to, for example, the jury room and wait in there. And then we'll bring the jurors in one at a time to answer questions from counsel. The goal is, I'm not going to stop you if you're getting important information that needs to be got to, but the idea is after that more group discussion, the individual voir dire will be more for very sensitive topics, also for knowledge they have about the case from media or otherwise, because I don't want them to talk about it in front of other jurors. And then other topics that you sense were too sensitive to talk about in front of the others. Hopefully we can get through each of the individual jurors in 10 to 15 minutes apiece, but we'll play that by ear. We'll see.
Ask a question?
Sure.
So the 10 to 16 people in the general session, is that going to be the court's few questions and then each counsel has general questions? And just to make sure I understand, then whoever's left from there, we pull in and then we talk about case-specific information, the media items?
Media items, correct.
Okay. And would you envision that during the time we talk about media items, I can also find out their views on capital punishment?
Yeah, it may be that you are able to talk about that with the larger group to a degree. There may be some who appear sensitive to that and prefer to talk about it outside, and we kind of play it by ear. So it's not a subject I'm going to forbid from being discussed in front of the larger group. And you'll have limited time with the individual. So, you need to balance how you're going to use that time.
We may have to see how it plays out, Your Honor, but in my view, talking about the views on capital punishment is fine in a bigger group. My preference would be to be able to get the media items, people that aren't going to make it, to let them go before we do that. I think it would save time to have them gone before we do the capital punishment views. If we know they're not coming, they're not going to stay because of media coverage and those kind of beliefs and views, it makes more sense to have them go before we start talking about something else. My concern is the amount of time and that the media coverage items might find their way into a discussion of capital punishment.
Well, I will make it clear to the jurors that they're not to discuss anything they may have heard in the media during that general session. And we'll play it by ear. If it's not working, we can change it, right? So let's, and this is very similar to the way Judge Boyce had done it. I think it worked well. They got a jury fairly quickly. Now, as much as the attention was in that case, obviously this one seems to have more publicity. But I think that handling it with first going through the general, because we're going to lose people based on hardship, based on, have they made up their mind? Yes, right, kind of stuff. And so we don't even need to talk to them. And then we can get into the issues, or they may, simply give a view of capital punishment in that one that it's clear that they're not qualified either one side of the coin or the other. But if you want to deal more if they're hedging or you're sensing some concerns, you can use that follow-up time in individual session to follow up on that rather than trying to do that in the public session.
Okay, so welcome, little Miss Susan just became a YouTube member. Thank you very much. I appreciate that. Welcome to the club. Also, I want to give a quick thank you to Miss Donnie. Donnie, and I didn't notice it until after the stream ended yesterday, but Donnie had sent super thanks or whatever you call those in the replay part of the thing. It was like I think they're called super thanks. I'm not sure, but it was a sweet donation. I appreciate that too, Donnie. Let me give you guys some sparkle for that. And one of these. Urgh. She's my favorite. She's always going to be my favorite. But thank you guys. I appreciate it so much. And hey, Miss King, good to see you. Good to see you. Miss King, I know you probably missed part of it, but earlier in the beginning of the stream when I started it, I was like, I have to go off topic of Karen Reed today because Kohberger, I can't help it. I can't help it. And it feels good. It feels, I hate to say the word refreshing because there's nothing refreshing about a horrendous, case like Idaho 4, right? Coming from the true crime, what we do every day, it is a little bit more refreshing for me personally because I'm over Karen Reed. Not her, but the trial. I'm over it. And I really want, at this point, the only people I care about being on the stand at this point is Proctor, Higgins, and some of the Alberts. That's really it. And again, another reminder, I will not be streaming tomorrow because kiddo has a couple doctor's appointments, and I won't be streaming on Wednesday because kindergarten graduation. So, I was like, well, if we're going to miss those 2 days, might as well not stream Karen Reed today too. And the Kohberger, this is the final pretrial hearing before the trial. So Margaret says I do that with my hairbrush when my ears don't work right. Hey, Kel, good to see you, girly. Good to see you, friend. Okay, here we go. And I was going to say, how would you guys feel if you were in Kohberger's shoes right now to have to be hearing this? I mean, most of this, like, housekeeping things are kind of whatever, you know? But when they start talking about the capital punishment phase and things, you know, he's sitting there, like, shaking in his boots, thinking they're just sitting here willy-nilly discussing whether I'm going to be in front of the firing squad or not, you know?
Any questions about that, just in terms of how the questioning will go? So my intent in terms of public access to the voir dire process is that during the group session, victims and defendant's family will be present. A small number of public seats will be available. And then it will be streamed to a larger room in the courthouse for anyone else in the public that wants to watch. It will not be broadcast outside of that closed circuit, because then I lose control of the recording in the event that a juror's identity is revealed, and then I get all the internet sleuths out there trying to figure out who everybody is, and I want to protect the juror's privacy as much as possible in that regard. And so
You
this does
talking
allow
about
for
us,
public access
Judge?
is the right, but
Internet
also
sleuths.
allows the court to tightly control that process. And then the individual voir dire will be counsel and the defendant only. And there'll be no stream.
Potential jurors' faces and names obviously won't be broadcast.
Correct. The faces will not be broadcast, and you are to only use their scrambled number as their identity throughout this. So they will never, you will never speak their name, nor will I or the court. It'll only be by that scrambled number, and the camera view will not show their faces.
The juror number by which we'll name them, will that be on them, or does this court use paddles so that their numbers can be held up when we want
They'll
to
have a
exercise?
laminated paper, like 8x10 paper that has cardstock laminated that has the number on it.
Thank you.
And it'll be the scrambled number, not their original reporting number. My goal is to try to get through 4 panels a day, which may not seem like it's much, but I know from the prior trial that they struggled to get 3 a day. So my goal is to try to get to 4 a day, but I want to get to at least through 3 panel a day. The plan would be is once we get through the number of jurors we need to sit, including alternates and peremptory challenges, plus a few extra in the event something changes before the time we exercise the peremptory challenges. Once we get that number, let's say that number is 50, that's where we would stop and then go to the peremptory challenges. Does that make sense? Any questions about that?
Just to clarify that I understand it, we'll get enough people that we get 50 that have not been challenged for cause and then
That has been
exercise.
passed for a
peremptories.
cause, correct. But once you get that, if you will, struck panel, then we will exercise the peremptories. With respect to the number of jurors, prior to Friday, I had intended to use 6 alternates, and after Friday, I intend to use 8 alternates for a total of 20. That's about the maximum that I can fit into the jury box that we intend to use. So that number, 20 plus strikes, which would be 12 strikes apiece pursuant to rule, gets us to, I think, 44. And so the plan would be to get, 50 to 55 that have passed for cause to bring back for the peremptory challenges in the event that we lose somebody for some reason in between.
They're going to max out on the alternates, man. They should, though. It's going to be a long trial.
Any questions about that process? Okay. So, and then when we're exercising the challenges, what I do is I give you a time limit geared to the number of peremptories that you have. So here, for example, you have 12 peremptories, give you each 30 minutes to exercise those. And it's a chess clock. So while the paper is with you. Your clock is running.
For sure.
And once you hand it to the bailiff, it stops running and the other side starts running. Once you reach your 30 minutes, absent some showing of something happened outside your control, then your peremptories are over. Now, that's usually I give 1 minute per peremptory in the typical trial. I'm giving you far more than that here. It shouldn't take that much time, particularly with the number of people that you have keeping track of everything. If you both pass on a round, or let's say the defense passes at the end of round 4, and then the state passes at the beginning of round 5, that ends the use of peremptory challenges, because you both have said to me, by passing consecutively, there's nobody that you want to strike. So understand that rule as you go in. After the panel is selected, the jurors and the alternates, which the alternates won't be determined until deliberations, when by lottery, who's ever left will be determined to be the jurors, and the alternates, those who are drawn by lottery to be an alternate. But that group of jurors, and so the 20, will be taken to another location in the courthouse. I will briefly meet with them, simply to introduce to them the people that will be talking to them, which will include the trial court administrator, the jury commissioner, and Judge Cawthon, who will be acting as it relates to this case as the administrative judge during the trial, to help them understand the process that we will use for juror security, for juror privacy, for reporting, and all of that, to answer any questions they have about that process, so they know where to go to ask questions about the process, and sort of, if you will, onboarding them. Counsel won't be at that, nor will I, other than to introduce the people. And then I will leave so that I don't inadvertently hear anything that I shouldn't hear on my own. I want to stress the importance of no contact with the jurors in any way by you, your staff, your witnesses, anybody affiliated with the case. And so they need to be instructed as to that. So if the juror, if you happen to see a juror somewhere else in the courthouse or at the grocery store or at the coffee shop, you're not to even engage in pleasantries. Turn tail and run the other way as fast as you can. If you have any contact with the juror, you need to report it immediately to myself and to opposing counsel, so we can then make any inquiry that we need to. I issued yesterday an order in this case regarding
I love how he said turn tail and run the other way. If you even see them in the grocery store, turn tail and run the other way. Hey, Mary Lou, good to see you. How are you feeling, and how was work been? Is things going okay?
sort of the rules of the road for those attending the trial, as well as an administrative order that I imagine will be on the court's website here if it's not already, outlining some of that as it relates to outside the courtroom. So my order in this case relates to the courtroom. The order, as I signed as administrative judge, relates to the courthouse at large. Make sure you have reviewed that and make sure your team understand that. There will be portions of the building that will be off limits to the public and to you. So make sure you understand that as well. I think I told you when you were here to look at the facilities, it's important that we know where it is you intend to stay as soon as possible, as well as any witnesses you put up, et cetera, so that to the extent that we ultimately may need to sequester jurors, which once it goes to deliberation, we will have to at a minimum, that we steer you away from whatever series of hotels that we've reserved as potentially available for us to use, that you're not there. So let the staff know if you intend to stay at a hotel, if you intend to put witnesses up at a hotel, you intend to have staff stay at a hotel. Let us know where that's going to be. You will each
Good
be
deal, good
assigned
deal.
a conference room outside the courtroom, and you'll be given a key to it that you may lock each day, that nobody, including janitorial staff, will have access to, where you can keep your papers and files if you'd like, or other materials, and use to meet with witnesses, et cetera, as we go along. All right, before we turn to the trial itself, any questions about the jury selection process or the jurors?
No, sir.
No questions, thank you.
So the trial itself, the plan is to go from Monday through Friday with the session with the jury beginning at 8:45 each morning and ending at 3:30. Once we hit a sequestered phase, whether that be, for example, in a penalty phase or earlier in the case, should it become necessary, I will likely extend the hours of the trial to fill up the jurors' days. Part of the reason to give some time at the end of the day is so that they can do the errands of life that they need to do. But if we are hosting them, so to speak, we don't have to worry about that, and I'm sure they'd rather have their day taken up moving forward on the case. So that is the general plan. Counsel and the defendant dressed, ready to go at 8:15 each morning. From 8:15 to 8:45, if there are issues to discuss, that's when we will do them before trial starts. As I encouraged you when I first started this morning about this, this would be a really good time to discuss anything that you've just uncovered that might be an issue in the case. We will likewise have a period at the end of the day from 3:45 to 4:30-ish to similarly address issues that may be coming up the next day or in the near future. At this time, I do not intend to have trial on October 2nd and 3rd. Because of a previous commitment that I have. I talked to you before about potentially being gone on the 14th and 15th. As of now, I've been able to make alternate plans. So for now, you should plan on being here for trial on those days. Holidays that I could spot quickly on the calendar include September 1, October 13, and November 11. So those are holidays for which there would be no court, with the exception that if we are sequestered, we may have trial, and we'll address that as we go, because I can't send jurors home for the holiday, and so we might as well use the time. Any questions about the trial schedule? Okay. All right, in terms of special needs that you may have for trial, I'm assuming there is no need for us to have interpreters for any witnesses.
No, sir.
And then technology needs, be sure that you make sure whatever technology you intend to use works in the courtroom in which we will be. The best way to do that is to contact Ms. Barrios, the trial court administrator, and reserve a time to come down and try it out. I also suggest that you use on your team somebody that is far more technologically savvy than certainly I would have been in your shoes. Perhaps you are, but it's important to have your own IT kind of person there to deal with any issues that may come up. If you have litigation presentation software and it's not working, you might get a short recess of a few minutes to work it out. But if it's after that, we're just going to move forward and you'll have to figure out something else to use. So it would behoove you to have staff there that can deal with that. Likewise, in the event that something comes up last minute and there's a need to redact some portion of audio or video or other presentation, that you have somebody there that can do so quickly and knows how to do so quickly. And I would encourage you to plan ahead to have alternate versions of such things so that if there is a concern that's unresolved going into it, you have version A and version B you can use depending upon what the outcome of that may be. Any questions about technology? In terms of what we provide, it will be a overhead, what we call the Elmo device, which is the device where you set a piece of paper down and it projects
Me
onto the
too,
screen.
Laura.
And then we have a HDMI link for your computer to present whatever you want to from your computer. That's it. That's our technology. So anything beyond that, you'll have to bring.
So just a couple quick comments. Laura says, I'm glad this judge is no nonsense. Me too. I know I've said this over and over and over, but I love this judge way more than I did the other one, Judge John Judge. Now, he seemed like a great guy, but I feel like he was trying to make everybody happy. You know, and he's like I feel like he's a people pleaser. And this ain't the trial for that. He was too wishy-washy and did not like to make decisions. This judge, however, is very no nonsense. He's like, it's going to be this way, this way, this way, this way. If you can't get your ish together, then we're moving on. You know, so I like that. But one reason why it's really important is with a trial this big and this long of a trial, if you just let things kind of go without keeping it very no nonsense, then who knows when it would end, you know? So I really like that he's keeping everything in line. A while ago, Susan said this. She said this trial will give me nightmares. I know. I know. Did you watch the Dateline special, Susan? Oh, it was so good. And then earlier, Laura also mentioned they're going to need those alternates, in my opinion, and I think so too. With a trial this long, if they're thinking it's going to be a 3-month-long trial, that's forever. Like, I feel like they would need double the alternates. You know what I'm saying? I mean, I know they can't do that, but it is going to be difficult. And I like that he is trying to have them do where they're like not sequestered at first and then eventually sequester them, because that would be forever and a day long. Hey, husband's home. Hold on. Quick second. Okay, sorry. He just got home. He's getting ready to go watch for kiddo to get off the bus. But about the alternates, though, they're going to need every one of them, I think. But not only for the reason that it's going to be such a long trial, but also with all of the media that's going to be going on. I don't know how many are going to go broke, you know? So, all right, we'll get back to it. Here we go.
All right, let's talk about seating in the courtroom, counsel table, and the trial broadcast. Each side, I think when we toured the courtroom, each side will have 2 counsel table put
Agreed.
together, which should give you, depending on how closely you want to sit together, anywhere from 4 to 5, maybe 6 seats at that table.
Yep.
To use how you wish for yourself and your staff, and in the defense's case, the defendant. As I also indicated, I would provide a small table behind defense because they're not really as close to the bar as the state would be. A table behind you where you can have staff, 2 to 3 staff members.
I hope not.
The state will have some room behind the bar, directly behind them for its staff. What I need from you are numbers. Understanding the space that you have in the well. How many seats do you need? How many seats are you requesting and how many seats do you need are 2 perhaps different issues, but in terms of requesting, this does not include, for example, the victim's family or the defendant's family, but for staff. So apart from the 2 or 3 seats behind you, I'm assuming that's enough for you. For the state, likewise, 3 seats, 4 seats.
You should be able to make that work, Judge.
I hope so too, Susan.
In terms of reserve seating for the victims, it will be for those statutory victims that was agreed to by the parties. And for the defense's family, it would be those 4 members that were identified in terms of reserve seating. What I would like to do, though, is I suspect that it's maybe that everybody won't be at trial every day. And so what I would like, excuse me, is for those that have reserved seating, in particular the victims, and I should point out, I am going to reserve 2 seats for the 2 surviving roommates who are technically victims of the burglary. I don't know whether they would have any desire to be here. I suspect not, given the way they've been treated in the media, but
Wow. So reserved seating for Dylan and Bethany. That's big. And like he said, he don't think that they would want to, I don't see, he says he don't suspect they'll want to be there, but just in case they'll have a seat, which is pretty awesome. And also, I don't know that they're going to want to be there. I mean, who knows? They may be, but I doubt it.
if they do, that they would have seats available. But anybody who has reserved seats, I'm asking that they notify the trial court administrator what their plans are for each week. So if you tell me you're not going to tell the TCA, I would like to know, for example, we're not going to use 3 of the seats on Tuesday. So that we know, so that we can make those seats available for the lottery system, or it's not technically lottery, it's a first come system on a computerized basis. But if we don't hear from you and you haven't made arrangements, we will assume that you don't intend to be here. So it's important that each week you let the trial court administrator know. She'll give you an email address if you contact her, where you can send an email to tell us whether you'll need all of your seats or not that week, and at which days you won't.
I'd love to be there.
That goes for
Oh,
both the
it'd be
victim's
awesome.
family and the
Wouldn't
defendant's
it?
family. Right now, the plan is, and this is subject to change, to have a reserved seating, I don't want to say reserved seat, a seat selection process by which people can go to a website each day and at a certain time, and it's kind of like buying concert tickets, indicate a desire to have a seat, and the first X number that are available that
Hey,
get through
Patricia.
will have a seat. It will be necessary to bring identification to show that you are who you are, or are who you say you are, to get into the courtroom. Again, that may be subject to change. I think the intent is for Judge Cawthon to have a town hall meeting with media in June, at a date to be determined later, to go over sort of what that process looks like, so that gets, so the media is aware, and so that then it gets publicized to the general public that would want to be here. My intent at this point is to allow a stream of the trial proceedings controlled by the court to be run on the court's, or if anybody's watching today, where it would be today, on the court's broadcast page. The views will include counsel table, the podium, the witness stand, and the bench. There will be no production of the video, meaning there'll be no close-ups and zoom-ins and zoom-outs and things of that nature. It'll be the static views.
Okay. So basically, it's going to be
Court
exactly
goes
what we're.
further when we're talking about the reserved seating for families in the courtroom. If we have some other members of Mr. Kohberger's family that
Let me rewind that back. Because he's explaining right now what we're going to be looking at during the trial, what we will be like. It's going to be basically like what we're seeing right now, the same kind of setup. And he's saying that the feed will be ran through the courtroom just like it is how we're seeing now. And he said we'll see the council tables, this, that, and the other, and I wanted to catch what I missed.
At a date to be determined later to go over sort of what that process looks like so that gets, so the media is aware and so that then it gets publicized to the general public that would want to be here. My intent at this point is to allow a stream of the trial proceedings controlled by the court to be run on the court's, where, if anybody's watching today, where it would be today, on the court's broadcast page. The views will include council table, the podium, the witness stand, and the bench. There will be no production of the video, meaning there'll be no close-ups and zoom-ins and zoom-outs and things of that nature. It'll be the static views.
So I'm really hoping that behind the witness, I can't remember. Does anybody remember if there's like a screen behind the witness? Like what if they put things up to be like published evidence-wise that you can see? Does anybody remember? I can't remember in any other hearings. I'll have to go back and look to see if there is a screen. Because I hope that they'll put evidence on the screen to be seen. Now, I know that they're not going to put everything up, obviously, right? They're going to be very cautious about that. But I hope that we can see some things, right?
So before the court goes further, when we're talking about the reserved seating for families in the courtroom, if we have some other members of Mr. Kohberger's family that travel and want to attend the trial, can we request an extra seat for a day for them?
Yeah, we probably be able to accommodate a few days here and there, but seating's going to be very limited, right? And so I don't want to extend that beyond the immediate family as a general rule, but if there's a specific day or two where there are going to be a couple other folks in town, talk to the trial court administrator and she'll see what you can do.
In addition to that, we have one other person on our team that would like to have sit with the victim or with Mr. Kohberger's family. It's not somebody who would testify. So if we could have 5 seats, it's somebody who will just assist them, as the media might try to talk to them
Sure.
a lot.
All right, I don't have a problem with that. I'm assuming the victim witness coordinator will want to be there as well, so.
And Your Honor, as the court is aware, we have, unlike most cases, we have multiple victims here. So we will have multiple victim coordinators to work with separate families. We will coordinate that with Ms. Barrios' office to let her know.
Are you talking about one per family?
Hopefully not like that, but we're going to need to split at least, we're going to need to have at least 2 separate groups.
All right, let's try to keep it as limited as we can just because seats are at a premium, but.
Yes, understood. Your Honor, may I also ask the court in regard to the live stream from the witness stand? I believe that we mentioned this at least in passing in our trial brief. The state anticipates that we may have witnesses who, for reasons the court articulated about the other 2 victims, surviving victims, that public live stream where their images could be captured and played games with in the media. Video of that live stream when they testify to be shut off and just have the audio. We also may have a small number of law enforcement witnesses who also do covert work, and broadcasting their images publicly would be desirable. We will advise the court. We've asked the agencies to identify anybody in that capacity and to specify the basis, which we'll bring to the court. I just want to give Your Honor a heads up.
Your Honor, this case is very high profile, and we've had people who have expressed reluctance to talk to us and being willing to testify for similar reasons. I did have a chance to speak with the state this morning, and we agreed that what we'd do is take a look at our entire witness list and try to figure out people that might be more sensitive to having their video camera on their face while they testify, and we may approach the court with a stipulation for certain numbers of them.
Well, my intent would be with respect to victims, and I've already indicated I think the 2 roommates are victims. There is a compelling interest to protect them. And so just as typically when media is present, they're not permitted to photograph or video victims that may be in the courtroom. If the victim requests it, their face will not be shown during the broadcast. In terms of those that work covert, I gotta see where the parties land on that. If they weren't covert in this case, I'm not sure about that. I'll have to think about that, and you may have to convince me, because I think there is public interest at play here. And so we'll talk about it.
Thank you. Yes, sir.
And as for anyone else, you're going to have to really convince me because of the public's right and their hesitance.
Wow. Interesting. Uh-oh. Uh-oh. Hold on.
Weren't undercover in this case. So
There we go.
other folks who may be shy, probably I'm going to have to weigh heavily the public interest there.
Or I wonder if the same could be accomplished with a room where there could be a feed for certain bits of testimony to a larger group, and it's still a public open courthouse, and live streaming something that gets captured for millions of viewers that lives on for a very long time.
Is it just me, or does the gal on the defense team that's sitting between Ann Taylor and Bryan Kohberger, the gal with the dark hair, does it look like she is always smiling? Like, it looks like no matter what, when you look at her, it looks like she's sitting there going, is it just me? You know? Yeah, Susan, that's what I thought you meant. A screen behind the witness, like in Letitia's trial. Yeah. I'll have to go back and look because there's been other pretrial hearings where they've had witnesses on the stand, where we've seen the witnesses on the stand. I think one of them was a cell phone forensic expert or something. And I can't remember if there was a screen behind him when he spoke or not. I'll have to go back and look. But it's interesting, though, that he's like definitely okay with not showing Bethany or Dylan because they're victims as well, right? Surviving victims. But the others, you know, the covert law enforcement and stuff. Yeah. I've seen judges do that before. And there have been other cases, especially that one in Ohio, the what was that? What was that case in Ohio? That trial. I forget their last names. Piketon County. Ooh. Where that one family basically massacred an entire other family. During that trial, they didn't show a lot of faces. So it was anybody who was like didn't want to be seen on camera. They didn't have to be seen. The judge let them not be seen, but you could hear the audio, right? Instead of RBF, she's got RSF, resting smiling face. She does. Is it just me? Does it look like she smiles all the time? I don't know. Maybe she's just naturally a happy person.
Time might be different, and I can work with the state and then give the court a little bit more on that, but off the top of my head, that's what I'm thinking.
It's going to have to be a very compelling reason to do it. So aside from victims, you know, while we are open in the sense that the people in the courtroom, the likelihood is we can't fit everybody in there that wants to be in there. And if I start not broadcasting the testimony, the full testimony of people who would otherwise prefer not to, that's going to fill up, that's going to be a large number quickly. And the best way that we have to ensure that the public is accepting of whatever verdict may be reached in this case is for the public to have the ability to see the evidence.
Thank you, Judge. Thank you.
So
We appreciate that as the public.
I'm not saying no, I'm just saying you're going to have to really convince me.
Thank you.
Right. I know, Aurelia. Santa's a lawyer in the off season, right? I love that beard. His mustache is always
All right, any
just like
questions about either the seating or
perfect.
broadcasting besides what we've talked about?
Was there?
All right, let's move to then opening statements. Let me start with what you've probably figured out by now. I am not tolerant of argument during opening statement.
Ooh.
So if somebody is arguing and there is an objection, it will be sustained. Please don't do it.
Nice.
What I would like you to do is, by about the time that we're meeting again to select jurors, let me know what you estimate the time you need for your opening is. I will then look at that request and give you a time allotment based on consideration of that request. Each side will be given the same amount of time, and then I will hold you to it. In other words, if you tell me it's going to take an hour, I'm not going to tell you you only have 30 minutes, right? But if you tell me you want 5 hours, I might have some questions about that. But if you tell me you need an hour and I give both sides an hour, in about an hour, you're going to hear me say, counsel, you've got 5 minutes left.
With as big as this case is, with all the victims and all that happened and all the evidence or suspected evidence, I would assume that the openings would take an hour minimum.
Use of exhibits or potential exhibits during opening statement. Because exhibits are not pre-admitted, even if stipulated to, there has to be an agreement to show the exhibit during the opening. Hopefully you both work together knowing what is coming in and isn't coming in, particularly where there's an agreement that something's coming in, other than spite, there's no good reason to not agree to it because the shoe will be on the other foot, so to speak, down the road. So courteous typically pays off with reciprocal courtesy. So work together on that. But technically, if it's not admitted, which nothing is by the time of opening, and there's an objection to using it, I would likely sustain it. For that reason, it's important that you, if you're going to use, for example, like a PowerPoint or something like that, that you share that with the other side at least 72 hours in advance so that they have a chance to review it and then work out any concerns they have and lodge any objections that can't be worked out with me, 48 hours in advance, so that I can then look at it and make a determination. If I haven't given you a ruling by that time and you're coming into openings without yet having a ruling, I suggest you have more than one version ready to go. One that is anticipates the objection being overruled and one that anticipates it being sustained. Let me reiterate again, please do not argue during opening statements or in voir dire, I should mention as well. Make a request at the beginning of your opening to enter the well and it will be granted. However, an invitation and permission to be in the well is not permission to invade the personal space of jurors. So understand that and stay a few feet back, at least from the bar of the jury well. If you are going to use a PowerPoint or some other presentation, you need to choose at the beginning of your presentation whether you want the lights on or off, and they will remain that way throughout your opening, rather than turning them on and off again. So I suggest you do a dry run based on what the light looks like at that time to see what that looks like, to see if you want it on or off. Any questions about openings? All right. Next, I have witnesses. Before we do that, let's take a break. We'll take 10 minutes and I'll be back, all right?
Wow, he is so detail oriented. I love this judge so much. He's my kind of judge. I love it. I love it because he's like, it's going to be this way, this way, this way, this way, this way. When he first started this hearing, he said, we're going to go over my what did he call it? This is my list of things that we're gonna, I just think he's awesome. I just think he's awesome. All right, so they go on a break, and then they come back. Let's scooch on past.
The trial court administrator,
Okay, here we go. Mr. Thompson and that luscious Santa
Who are the
beard and
witnesses?
mustache. Hey, Cherie. Good to see you.
by 5 o'clock each day,
Yes, he does.
you need to give notice to the other side by
Oh,
5
wait,
o'clock each.
wait. What did he say? I think it skipped or something. I didn't catch
Moving on to witnesses.
witnesses.
The, by 5 o'clock each day, you need to give notice to the other side
Okay.
witnesses that you will be calling that next day.
Okay.
If it's over a weekend, by noon on Saturday. The list should be a realistic one and not everybody on your witness list. And it should be tiered into two. One is the ones that you definitely are going to be getting to. And then if you have time left over, who you would take and in what order.
He certainly does, Kel. You have to be that kind of
Do you,
judge.
like to use the time.
I've already said this once, but I want to reiterate. You have to be this kind of judge to run this massive of a trial, this size of a trial, and this high, what's the word? Well, what am I looking for? This is a super high something. What is the word? High profile, I guess, of a trial. You have to be that kind of a judge. I cannot imagine Judge John Judge running this trial. So yeah, thankfully we have Hippler.
Efficiently. So I do like to use the time efficiently. So I don't generally grant the request if we're normally stopping at 3:30 at 3:10 or so to say when you end a witness, well, can we just stop here? The answer is generally no. Let's use the 15, 20 minutes that we have because in a 3-month trial that adds up at the end of the day. So have enough witnesses ready to go to fill the time. And it's always good to have one or two who you always have at your site. So for example, if the state, a law enforcement officer, who's there, for example, you can call and put on something if worse comes to worse. But I want to make sure we use that time efficiently. In addition to giving the list of witnesses you're going to call, you need to provide a list of exhibits you intend to introduce with that witness, short of obviously impeachment, so that the other side can look at those. That doesn't include exhibits that you would put in as part of redirect examination. So for example, the defense in the state's case cross-examines on some other exhibits that you didn't bring up, or there are exhibits that you didn't bring up that would explain what the defense brought up. You don't have to give notice of those exhibits. You don't have to anticipate that, in other words. Now, this is not a remedy or a right that I'm likely is going to be resulting in exclusion of evidence. It is something that you're going to have to deal with me if you're not complying with it. And I will figure out something to make sure that you do, although I don't expect it will be a problem. You should know what exhibits you're going to use, and there's no real secret here about what exhibits go with what witnesses. And I say that because there's always going to be leeway where you have an exhibit that you forgot you need to use, or a witness testifies in a way that you now need to use another exhibit. So, there's leeway there, but giving the other side a general idea of the key exhibits that will be used so that they can review those to prepare, I think is fair. The corollary to my use all the time that we have is don't filibuster. I will give an example that I have used, that I have violated my own rule in the past. When I was in your shoes, where I had a young associate handling a witness who, the next witness was going to be the client, and we didn't want to get to him that day, and he kept turning around thinking he was done, and I kept going like this, meaning fill up the time. Don't do that. Use the time efficiently, but don't filibuster. I've learned to come, as a judge, you sometimes feel like your client is the jury in some ways, right? You want to make sure that that they are comfortable. You want to make sure they're treated with respect, and make sure that things go as quickly as possible for them. And so I've come to respect that. And so I tend to want to make that happen as much as possible. So, don't waste their time, either by having gaps that we can't fill or by filling it with stuff we don't need to use where we could be going to another witness. The lawyer handling a witness, if that is the lawyer handling on direct or the lawyer handling on cross, is the lawyer authorized to speak on the issues related to that witness's testimony at the time it is being offered? And so that is the only lawyer that's authorized to speak about that witness. So if there is a sidebar, only the lawyers handling the witness need approach. If it's specific to that, if it's more general and I need to talk to more of you, I'll let you know that. But I don't want the whole caravan up here for those discussions. Likewise, please do not stretch the shirt sleeve of the lawyer who is handling it by the other lawyer constantly pulling on their sleeve and writing a note and saying, don't say, they'll get it. Just let them do their job. I'm assuming that there is, based on our prior motions, a agreement, well, I'm assuming at least one of you would like to exclude witnesses pursuant to 615. Because if that's the case, then they will be excluded, generally speaking.
It was the state's expectation that that's what would occur, and that's why we raised with the court earlier on the specific individuals that we've agreed could stay even if they haven't testified yet.
So 615 is one of those rules where if one side requests it, it's granted as a general matter. And so I'm assuming that we're going to be using 615 to exclude witnesses except those excluded by or excused from it by the court. Or you can agree not to use 615.
I want to talk about experts, though.
Right.
Experts being allowed to view other expert testimony.
Correct. Experts are generally excused from 615 because part of what they rely upon is the testimony of other experts. Part of what they rebut is the testimony of other experts. So experts generally are excluded. The parties, or in the state's case, a designated party representative, such as a lead investigator, is typically excused from it. I've already talked about the defendant's family in another ruling, and crime victims are excluded from it.
I want some further clarification with our experts.
And I think you guys agreed that your investigators would be excluded from it as well.
We did make that agreement. I think that may have even been in writing.
Yeah. I'm sorry, I didn't mean to interrupt. I just had that thought. I didn't want to lose it.
No, that's okay. I know the court has talked before about the live streaming and being mindful that witnesses not watch the trial when they're outside of the courtroom, just like they couldn't inside of the courtroom. What I want to know is with experts who are allowed to be in the courtroom, can those that are far away watch the live stream version if they can't make it to Idaho?
Mr. Thompson? You have any objection to that?
No, that seems to make sense, Your Honor. And I understood that the court was going to get an admonishment, acknowledgement from witnesses as they appear.
Bailiff, would you provide one of these to each side, please? This is an affidavit that each witness will have to sign, and you hand to me as they are going to the stand when you're called by them, specifically declaring that they have not watched the live stream. This is for witnesses who are excluded or otherwise consumed media about the testimony or evidence presented during the trial. That's not the, I'm not wed to the exact wording, so if you have wording suggestions, I certainly will listen to them, but that is the gist, is that they will provide such an affidavit each, as they come to testify. Any concern with that?
Not with the wording at the moment. A question of clarification, though. If the case should reach a phase 2, does this admonition apply to those potential witnesses for phase 2?
So a witness who is only a phase 2 witness,
Only a phase 2, yeah.
and they attend phase 1, is that what you're asking?
If they watch or attend any part of phase 1.
Well, the problem with that is that phase 1 is also part of the state's phase 2 evidence, as is the defense's, right?
Your Honor, I think that would support the need for them to be able to know it if the state's going to rely on things that
Are you talking about experts?
experts and possibly lay people too.
Oh, explain to me why lay people should be excluded from it.
I don't think they should be excluded.
So you think they should not be permitted to watch the trial?
I think I've got some double negatives going on. I think that if we get to a phase 2, I don't think that those witnesses have to be excluded from paying attention to phase 1. I think the protection for phase 1 is separate than phase 2 because of the rules of evidence that apply to any phase 2, the lack of them that apply to phase 2, and because the state's going to rely on what was in phase 1. So yes, experts and some potential lay witnesses as well.
Mr. Thompson or whoever wants to address this?
Our initial inclination is to leave that to the court's discretion. I think the whole purpose is to avoid prospective witnesses altering their testimony in some fashion based on what they've seen going on in court. That's the danger. I don't know why phase 2 witnesses should be treated any differently than phase 1 witnesses.
Well, what I'm going to do is, I'll give you a chance to each submit something within 7 days in writing on that, and I'll look at it so that you can give me any authority that you might come across related to that issue. Give me a chance to think about it further, and for the two of you to perhaps talk to see if you can understand specifically who you might be thinking of to see if the state has a problem with that. All right. Counsel who calls a witness, unless it's clearly an adverse witness, in which case counsel needs to notify opposing counsel that they have not admonished that witness. But otherwise, counsel is responsible for ensuring witnesses are aware of orders in limine, otherwise clearly off testimony that is off limits. Make sure they understand, the Rule 615 requirements and the fact that they're going to have to sign an affidavit subject to the penalties of perjury that they have not watched this stuff. So it's your responsibility to make sure that they're aware, because when they don't comply, I'm going to be asking, why did you make them aware? While we were talking about the jury, I failed to give you the juror affirmation that will have to be signed by the jurors each day. Let me give you a copy of that along the same lines. So that is an affidavit each juror will fill out daily, indicating that they have not violated the court's instruction or otherwise been exposed to testimony or information about the case outside of the trial itself. If I exclude evidence and you need to make an offer of proof, the opportunity to do that generally is when the jury, when we're not working with the jury, such as the morning session or the afternoon session, so that you can make that record as best as possible. That can be done typically by simply making oral reference to what the witness would have testified or what the evidence would have shown had it been admitted. Okay, let me, I think the rules are pretty clear, but some judges may have more leeway than others about objections. Let me explain to you what my expectations are regarding objections. So objections to questions or exhibits should be stated simply and without argument. It should not be a speaking objection. So for example, an objection, a proper objection might be, for example, objection hearsay. Objection foundation requires a little more. As you're probably aware, there's case law that is an insufficient objection. You have to identify what is missing from the foundation as part of your objection. If you think that doing so would put information in front of the jury that you're not certain I'm going to allow, please ask to approach. I tend to be a rather quick on rulings, on objections. I've been known to, testimony, objection, overruled, sustained immediately, without even giving you much of a chance to express your concern greater, because I can usually anticipate what the potential issue is and whether or not it's an issue. That's it. If you think your ox has been gored and you need to address the issue more, either to have a record or in order to perhaps convince me that I'm maybe looking at it differently than what you anticipated or than I should, please just ask to approach, and then we can have a discussion here at the bench about that. If you need to make a further record for any reason on an objection or in response to an objection, simply ask to approach and we will have that discussion. I'm sure by the end of the trial, we'll have to replace the carpet from the trail leading from counsel to the bench, but that's fine. As I've shown you before, the court reporter will have a device like this that will allow her to hear through her earphones what we're saying. There will be white noise that's played in the courtroom so the jury and others cannot hear what we're talking about. There will be a physical barrier that blocks most of the view of the jury from what we're talking about at the bench that's rolled out so that they can't see. And we can have fairly fulsome whispered discussions here at the bench about that, whatever the issue may be. I have found in, doing this for far longer than I care to remember, that when I send the jury away to hear argument on an objection, what might take 3 minutes to have the argument on takes 12 to 15 minutes to get the jury back again. And then we lose a lot of time throughout the day that way. And so my preference is, as much as possible, to have those discussions here at the bench. Now, if it's a very significant issue that requires much more leg room, so to speak, to talk about it, then I will chase them out of the room, but I prefer not to handle the more routine stuff. One of the things about, I've had counsel before who confuse the idea of the need to make a record with the need to get my ruling and then offer a rebuttal to it. That is not making a record, that is making a rebuttal. And at least until it goes over to State Street, I get the last word and not you. And so I don't generally afford that opportunity. So if after I rule and you tell me you need to make a record, it truly needs to be a record on something that for some reason you were unable to make when you had the opportunity to do so, and not simply to see what my ruling is and then try to pick it apart. I will reiterate what I started with is I don't like surprises. If you anticipate an objection or you anticipate objecting to testimony you certainly know is coming, let's talk it over before the witness hits the stand, before the jury's in the box, so that I have as much time as possible to be prepared so I can give you as best a ruling as I can, and so that you can make as best an argument as you can. If you anticipate the potential impeachment of a witness by prior testimony, whether that's grand jury testimony, whether that is transcribed witness interviews, whatever it might be, please get that to me before the witness hits the stand, and preferably towards the start of the trial, so that I have that available so I can have read it before the witness testifies, so that when you then ask to either impeach or to refresh recollection or whatever it might be, I will have read that testimony. Don't be mistaken in your belief that I have all that testimony. If it, for example, happened with Judge, I don't necessarily have all those transcripts, so get them to me. Or if I do, they're in one of 100 boxes somewhere back there.
Your Honor, if they've been supplied with exhibits and the purpose was just for that, will that be enough for the court, or should I have an extra transcript at the start of the day if I think I need it on paper for it?
So let me know as far as advancing possible, and I will have staff look for that. But otherwise, it's probably safest just to provide me an actual copy of it.
Thank you.
While I'm thinking of it, because I'm in my mind envisioning the materials from grand jury that we have here, the state did file a motion to get back its exhibits for use at trial. I assume there's no objection to that?
Correct, no objection.
All right. Mr. Thompson, if you may make arrangements with staff here to get those while you're here, okay?
Yes, sir.
And I assume you have replacements you have or will get to me for those.
And actually, we had a pretty procedural question we were going to ask the clerk, but I'll ask Your Honor.
Clerk probably knows better than I do, but I'll go ahead and try.
We can do one of two things. We can either get together a set of photographs or copies of the exhibits and exchange those for the exhibits, or take the exhibits, document them, and then give the clerk what we've documented. We're happy to do it either way.
Well, my only fear is that you take the exhibit and then I don't know what the record is of what it actually looked like. Not to suggest that you would be involved in any chicanery and switching something out, but just trying as best I can to preserve that record.
Understood. So we probably will not pick them
Okay.
up on this trip, but we will make arrangements to have that done certainly well before trial.
Very well.
Thank you, sir.
Speaking of chicanery, I'm not fond, and you folks know that by now, of making accusations against opposing counsel that are not well-founded and supported by specific actual evidence. I know that you can get along, but I also know that over the course of a trial, particularly a long one, tension rises. And so I remind you of that to be professional. Don't talk to each other directly when we're in court, right? When the session's going, everything goes through the court as you know, the protocol with courts generally is. Refer to each other by professionally, Ms. Taylor, Mr. Thompson, not by first name while we're on the record. Again, avoid making accusations that you don't have the tickets for, or the receipts for, I should say. And under no circumstances should you make such accusations in front of the jury. It's a long trial, so as much as I want you to be prepared, you may have a local witness and a witness who's flown in that needs to get out again at the end of the day. And so it may be that we need to stop one witness's testimony to get the other witness in and then pick the other one up. As long as there's no clear prejudice from that, I'm generally flexible in allowing that so that we can accommodate that. And I ask you to both be accommodating to each other in that regard. All right, any questions about witnesses' testimony?
Just one, and kind of a takeoff of what the court just mentioned. We have at least one, maybe a couple law enforcement witnesses in particular who have testimony relevant to different stages of the case. And it's our intent, with the court's permission, to call them at different times instead of trying to figure out how to call them once and have them talk about what's going on at this stage of the case and then what may be happening next week with the case. Is that acceptable to the court?
Well, let's start with whether it's acceptable with Ms. Taylor.
Your Honor, I don't know that I have a strong objection or really any business in telling the state how to put on their case. That feels really cumbersome to me. I was hoping for leeway the other way when we would call a witness ourselves, but they're a state's witness. I'd hope to have a little leeway to do all of my examination so they didn't have to come back. I would otherwise defer to the court.
Certainly, if you're somebody's on your witness list, if you want to go beyond the scope of direct as part of effectively your case in chief in advance, I don't have a problem with that. And so if it's going to save bringing another witness back, I don't have a problem with that. I don't have a problem if it doesn't get too cumbersome. If we're having a law enforcement talk about a broad area of one phase of the investigation at a time, that's probably okay. But, having them come up and narrate between every other witness is probably too much. Then the question becomes is how do we handle cross-examination? And basically I will defer to the defense on that or the other side on that to the extent that we allow it, which is, do you want to cross-examine about the information they just presented now? Or do you want to wait until their last presentation and cross-examine about everything? And so that'll be up to you.
Your Honor, with that said, then I guess I'd request that the state let us know when they call a law enforcement that's for a limited purpose right now, but is coming back for another purpose.
Yeah, they need to let me know that as well.
Yes, Your Honor.
And if you don't let them know that, and, well, either way, it's your responsibility to ensure that they're back at some point available to the defense so that they can cross-examine, even if you decide, oh, I don't need them anymore. You better not send them on an airplane somewhere where they're unattainable, because the remedy may be to strike all of their testimony as a starting point.
We would anticipate asking court and counsel if this witness may be excused if we're finished with them. And then I would give Ms. Taylor or other counsel an opportunity to let us know whether they still need that person.
Okay. Likewise, when you look at each other's witness lists, talk with each other and then write it and get it in writing so we have it as to whether or not, for example, Ms. Taylor will need subpoenas to witnesses you have on your list that they want to also call, or if the other way around, you need subpoenas for their witnesses, or whether they will essentially agree to make them available. Anything else with respect to witnesses before I move to exhibits?
Okay.
Okay. All right. So I did require a meet and confer for you to go over exhibits, and I got those, and I appreciate the start that you have on those. There are a number of exhibits where there's appears to be, I can't tell. So for example, there's an objection to, for example, relevance or hearsay. Part of what I wanted to know, though, to start is, regardless of whether it's ultimately admissible for those reasons, is there an objection to authenticity? In other words, I want to make the trial go as quickly as possible, avoid the need to put on a bunch of witnesses simply to say, this is what this is, and they don't really have any substantive discussion about it. They're just authenticating a document that, if we were to be honest, there's no dispute that it is what it is. And so I may have you go back and look at that and add another column to the list, which is objections to authenticity. Now, some of the stuff, key actual evidence items, whether that's DNA or whatever it might be, obviously the defense is entitled to put the state to its burden with respect to chain of custody and all that. So I don't expect that. But on some of the other stuff, certainly to the extent that we can agree that if there's no good faith basis to contest the authenticity, then let's try to do that for everyone's sake. In that vein, I know the state had to withdraw its request to have certain documents self-authenticated to go back and do more work. Where are we at on that?
Ms. Jennings can speak to that, Your Honor.
Your Honor, I believe that we've submitted all of the certificates of authentication for all the exhibits we plan to introduce that way.
Okay. And you submitted those to the defense to review?
Yes.
And Ms. Taylor, are you going to respond to those?
Your Honor, we did. We met with the state last week, I believe, or the week before, and we discussed some of those records. There were some issues with them. Ms. Jennings provided me with a thumb drive, and I don't know if those have corrections on them, but I'll continue to let the state know what we think, if we continue with an objection or if we're satisfied that the rule's been met.
Okay. If you could get with each other and then provide me, I didn't study the exhibits that I got a day or two ago, or the spreadsheet that closely, but make sure I'm aware specifically of which exhibits there is no objection to the self-authenticating or otherwise not an objection to authenticity. Doesn't sound like we're going to need a hearing on that, at least for the time being, though.
Not that I'm aware of now, but certainly we'll keep our eye on it. I can alert the court, and if we can squeeze it into June 18th, that's possible. Maybe we
Sure.
can start that at noon.
Okay.
Okay, quick little cafe sidebar. Cafe sidebar, really quickly. I found some more of my favorite. Kel, are you still here? This was the stuff I was talking about. This is so good. It's Sparkling Ice is the name brand of the water. And it's the Starburst Strawberry Zero Sugar. This stuff is so good. And when you find it in the stores, grab it because it's gone. Gone like the wind. Bullseye. I can't ever find it. And so when I do find it, I like stock up on it. Anyway, it's very yum. Very yum. All right. That was my quick little cafe sidebar. Sorry.
And then I would certainly caution, at least because the state goes first for now, I'll say the state, that, belts and suspenders are good ideas when it comes to trial. So I would have my people I need to authenticate things under subpoena, just in case. Especially if they're out-of-state witnesses, because that's not something you can do overnight. So the methods of displaying evidence to the jury, generally there's 3 ways to do that. One is by putting it on the Elmo and projecting the physical document, whether it's a writing or something else. The other is if it's a writing or something else, using litigation software of some kind to project it through the computer. And the third is passing it through the jury. That last one is the one I want to avoid as much as possible because that just takes too much time. So try to use the other 2 approaches as much as possible. Now, there are going to be some physical objects that it may be important for the jury to see, and I get that. But in general, photographs, things that are in writing.
I don't know why it keeps freezing. Their stream does. It's not mine. It's not on my end. It's on them.
But identify it with the witness
Okay.
or process if
There we go.
the process, if there's a stipulated to exhibit, would be to, just as you normally would, identify it with the witness, or not even necessarily doing that. You're going to use exhibit 6. Witness is on the stand and just say, Your Honor, I'd like to go over exhibit 6 with the witness. I understand that the defense has no objection to this. Look at you. That's correct. All right, exhibit 6 is admitted, and then we go from there. On voluminous documents, if possible, try to avoid sending the whole thing back if there's only a small part of it that's relevant. If that's not possible, let's highlight the parts that are relevant and maybe even explain through the witness whether any of the rest of it is relevant, right? So that they know what to look at. In that same vein, if you have a voluminous exhibit and there are, say, 5 or 6 pages from it that are important, what I might suggest is the exhibit be, exhibit 47, and then you have 47A, 47B, 47C as marked exhibits. They go with 47, but they're separate exhibits so that the jury can keep those in mind, and we can keep track of those. It looks like from what I received, the state's using S-number for its exhibits, and the defense is just using numbers. Is that accurate?
It is.
Hopefully that won't get too confusing for people. Where we can, what I also suggest is that the defense is going to use as part of its case the same exhibit that the state has used and admitted. Let's not admit another copy of the same thing. Let's just use, it's like to say the parties don't own the exhibits once they're admitted, the court does. And so there's no proprietary interest there. So if you already have it admitted in the form, just use that exhibit. Okay. I think my staff explained to you that in terms of submitting exhibits to the court in advance, if you would provide 2 copies of the exhibits in notebooks, so 1 copy in one set of notebooks and 1 copy in the other set of notebooks, and try not to make the notebooks bigger than about 1.5 inches each, at least on the copy you give to me, because it's just too unwieldy to use a 6-inch binder up here, or if I need to take it home and read it overnight to do that. So try to keep it to about 1.5 inches per. And then for the actual exhibits that are going to be admitted, provide those first day of trial or whatever to the clerk in each exhibit in a manila folder with the exhibit number marked on the outside of the folder on the tab with a sticker attached inside the exhibit, so that she'll have a box of the proposed exhibits, the originals, and you can ask for exhibit X or whatever, and she'll hand it to you to use. At least for the document exhibits and photograph exhibits. Physical object exhibits, work with the marshals on getting them in the courthouse. So for example, if it's something that's going to raise alarms at the security line, such as, I don't know, a knife, make sure you've got the aid of security in advance to get through that. The TCA can direct you to the marshal service and who to talk to there. We tend to use for dangerous items like guns and knives, a display box that the item would then be locked in to display to the jury. And so that can go to the jury without fear of an accident happening. I don't think there are any guns in this case, so I'm not as worried about that in terms of those being pointed at anyone by accident. But in terms of the knife, it'll probably be in a display case. If you're going to be using illustrative exhibits, give counsel notice of that as reasonably far in advance as possible for them to have a chance to look at those. Items for which chain of custody needs to be maintained until it's admitted, I'm going to leave that to the state to figure out where it's going to be stored and how it's going to be stored. Whether that's with the sister agency or whether you're going to have the sheriff up there bring down a trailer that can be locked up and kept at the sheriff's here property or something like that. However you want to do that, I'll let you worry about that. For physical objects, also provide color photographs so that we can have those in the record. At the end of the trial, we will likely give back physical objects to law enforcement to maintain, depending on what it is, we'll see, and depending on what the outcome of the case is. But it's nice to have those color copies available for the record. Triple check all of your exhibits, particularly documents, audio, and video, to ensure that there's nothing on there that is not supposed to be on there. Give audio and video to counsel far enough in advance they have the opportunity to determine whether they have an objection to anything in there, and you have the opportunity to either make redactions in accordance with the objection or to get a ruling from me about those redactions. What I don't want is the jury to be sitting in the back room while you all are making redactions at the last minute during the middle of trial. All right, for closings, kind of the same idea. I'll ask in advance for a time estimate, and then if it's reasonable, agree to it, but then hold you to it. A little bit more liberal, obviously on closing than an opening. If you're going to display things in closing, kind of the same light rule goes, which is lights on or lights off, so you'll have to choose. You can move about the well, but don't get in the juror's personal space. The state, when it gives me a time, I will keep track of that, and then for rebuttal, it'll be whatever you didn't use. So when you're giving me estimates, include your rebuttal in them. If you would like time reminders from the court throughout it, for example, if you're planning to keep 20 minutes for rebuttal, you can ask for a heads up at 30 minutes or something like that when you have 30 minutes left, so just let me know in advance. right, questions either about closings or about exhibits?
Your Honor, as to the defense exhibits, it would be helpful if they could be separated or at least delineated between which is for the penalty phase and the guilt phase. As the court will see when it looks at our spreadsheet of our responses to the defense exhibits, some of them, we could see we wouldn't object to them in penalty phase, but we would in guilt phase, and they aren't clearly delineated at this point. If that's something that we could have addressed sooner than not, that would be very helpful.
Any problem with that, Ms. Taylor?
No problem. We did go over that when we met last week, and I identified which ones were for a phase 2 if we get there. I don't have a problem stating so, but we did make them aware.
Okay, well, maybe if you can just put it in writing so that they have it, that'd be helpful. That way we don't have any misunderstanding between the two of you. Thank you. All right, once you get and revise your spreadsheets based upon what we've talked about today, I'll start about part of what I'm going to do with the time that we have between now and trial is start going through all those, looking at what your objections are, getting my preliminary thoughts together on that, and then we may have another hearing just to kind of go over some of that if it's stuff that I think I can rule on in advance for you, or if I have questions, et cetera, but I'll let you know. All right, anything else before I move on to jury instructions?
Not for much, Your Honor. Thank you.
As far as objections, Your Honor, the court has issued a number of decisions on motions and limine motions to dismiss. From the defendant's trial brief, the defendant indicates that he plans to raise those same objections again at trial. And it strikes the state that if that's going to happen, to preserve the record if for no other reason, that should be done outside the presence of the jury, as opposed to interrupting testimony and presentation of evidence on matters that have already been ruled on by the court, if that is acceptable to the court and counsel.
So there's not a need to object again if I've already ruled on the objection. If you're asking me to reconsider, yeah, I think that's something you need to take up outside the presence of the jury, if that makes sense.
That does make sense. And on situations that may arise where we might want the court to reconsider, we'll definitely take that up outside the presence of the jury. I do want to make sure that things such as the model house that was the subject of a lot of objection, that there's a noted ongoing objection to it. I don't mind anticipating that and bringing that up before trial starts and outside the presence of the jury.
And to be fair, I only have what was proffered, right? And so I had a general proffer that the testimony will be that it, as I understand it, that it is consistent with the general layout, but not to scale, and that it would be with the general layout, but not to scale, and that it would be helpful for the testimony. I don't have a problem with an objection based upon what that proffer is actually at the time. And so I think that's fine. I don't think that there's a need for an ongoing objection once that's done, but that helps.
Yes, sir. Thank you.
Jury instructions, I provided to you, I think yesterday, maybe pre-proof instructions. Did you get those?
I did not receive those.
Have we not sent those out? All right, I'll send those out probably today or Monday. They're not particularly, I think, controversial. They're pretty stock. On the pre-proof, in a capital case, there's a instruction. Normally what we instruct the jury is don't concern yourself with punishment, the subject of punishment. In a capital case, we are supposed to instruct them under 700B of the capital instructions in the pre-proof phase that it is a capital case, which obviously they're going to know through jury selection. So there's that instruction in there. And what I've done is we're also supposed to instruct them with 700C, which is this is a capital case and you'll have to decide if you find the defendant guilty, what penalty to impose. But then 700C says, instruct them in a separate instruction, don't concern yourself with the subject of penalty or punishment in the guilt phase. I've combined those two things together. So take a look at that. I think it reads better than trying to do two separate, potentially contradictory instructions. I think it does it in a way that makes it more understandable. Other than that, they're very, very stock instructions. If there are other instructions that the parties want to be included in the pre-proof, for example, any stipulations that they want me to advise the jury of, let me know by submitting a request and copying my law clerk on that as well. I think you'll probably get before too long a set of post-proof instructions that are very loose in the sense that obviously I can't anticipate everything. It is based on what I sort of understand now. But it's helpful to have a discussion about that as early as possible so that we're all singing from the same hymnal in terms of what the likely instructions are going to be. And, for better or worse, as you know, the Supreme Court in last year, 2024, revised all their capital instructions. And so in light of that, I will be as much as possible sticking with what they have provided, given that it's clear they've obviously given it recent thought. And so I think that best insulates the case from perceived error by the court is by using instructions they've recently given us. My plan would be, if there is a guilty verdict on any of the counts of murder, would begin the penalty phase as soon thereafter as we can. Certainly probably the next day, unless it's, Friday morning when we get that, then we may not start till Monday or something. But given that the jury will certainly be sequestered during that process, the plan would be to go forward. I also will use as much time as I told you throughout the day to get that accomplished as we can. If that happens and we are in a penalty phase and there is a finding of aggravating circumstances, or then the court's discretion about which penalty to impose is pretty limited in terms of my discretion. In fact, i.e. none. It's either life without parole or death, right? In that case, I just want to get, before we get to that, defense's position on sentencing for the burglary charge, if they have concerns about sentencing at that time as well, given that it's probably not even a tail wag on the dog, let alone wagging the dog. So, but I'm not going to make you tell me that now, but I will ask you before the jury goes out what you want to do. I'm going to hand you another piece of paper that I would like to get back from the defense sometime in late June or early July, which is a declaration of last best offer. In other words, identifying whether the defendant received an offer and whether he has accepted, rejected, et cetera, just so that for purposes of post-conviction, we've documented that. Okay. Let the court reporter know whether you're going to want routinely daily transcripts or not. You don't have to tell her now, but
Daily versus real time?
so there's two options. You can have none, both, or all, or either. One is I think we can set up real time where you get real time at your table for whatever the charge is from the court reporter for that. Also, there's the potential to get transcripts each day. I don't think those things are mutually exclusive. In other words, you could order both.
There's separate fees if I want both.
Correct.
Yeah, make that decision.
Yes, not now. You may make that as we get close. And just contact the TCA and she will talk with the court reporters that will be assigned to this to make sure you understand what their structure is, or fee structure.
Thank you.
And we obviously need to know particularly about the real time in advance so that we have the technology set up for it. And it may require you to bring some of your own technology in the form of a tablet or a laptop on which it's displayed, right? Because we don't supply the hardware, just the software and the actual reporting. Okay. My plan today, as we sit, is to get through the jury selection. I see where we're at with the intent that we not sequester to start. As I explained this morning, the more people talk to the media and the more things that are in the media that are not admissible, whether true or not, the more difficult it makes things. And so I'm going to have to figure that out as we get close. For now, intent is not to do that, but we will have plans in place to revert to that if we have to at any point during the trial. Do either of you want to make a record about sequestration at this point?
I would say the only record right now is that we understand what the court is saying during jury selection. If we still don't know if that could come up, the potential jurors should just be aware that it could come up prior to
It'll be
these
part of
two.
the question that the questionnaire, as well as part of the hardship determination is there some reason they would be unable? I get that they wouldn't like to be, but would there be unable? Do they have a sick family member they care for or whatever, where they have to be home, right? So we'll talk to them about that. Anything from you, counsel, Mr. Thompson, about that?
Not at this point. I understand the court might entertain some things in a closed environment later today, and we do have some sensitive issues to raise at that point.
Okay. That's my list of things. Did I miss anything, Giovanna, that you think of? All right. That's my list of stuff, and I know this has been a very sort of nuts and bolts kind of lawyer discussion today, but that's generally the nature of pretrials when there aren't contested motions to discuss, and so that's my list. I'm happy to answer any questions about my preferences or how I handle things that I haven't talked about, or address anything else that you want to talk about. I know we do need to go to a closed session at some point to talk about what will be asked of the jury specifically. I need to avoid that getting out to potential jurors, so we'll do that in a closed session. But anything else in the public session we need to talk about?
I don't believe so, Your Honor. Thank you.
Your Honor, thank you.
Okay. Let me just look at my notes real quick before I dismiss the public, and we probably take a lunch break and then come back and take that up. I do have a copy. I told you there's a new administrative order. I'll give you a copy of that just so you don't have to go dig for that. What's that? You've already given it to him? All right, perfect. Thank you.
It's fair that we could have, Your Honor.
Sure.
Oh, okay. It's already at hand. Thank you.
Actually, I have copies of the preliminary instructions for you.
Oh, thank you, sir.
In the closed session this morning, I indicated to you I am going to be entering an order requiring retention of records by the state, and I'm going to write another one extending that to the defense as it relates to violations of the non-dissemination order. I'm going to give you a copy of what that order is going to look like that I will execute likely over the lunch hour. It does require some action on your part, counsel. And as I indicated, I would be open to a request for a appointment of a special prosecutor, and that special prosecutor to ask for a magistrate inquiry so they have the power of subpoena and the power to question witnesses under oath, as well as the power to grant immunity. So I will be looking for that from you. And that one just deals with the state. I will get you one that deals with your side to preserve records, all right? All right. Anything else? All right, thank you. Why don't we come back in about an hour, all right?
All right.
Okay, so let's see what we got. As far as the house being torn down, Susan, I was devastated, I think, along with many other people. It was awful. It was just awful. I don't think it should be legal either. However, Spence had mentioned, she said, how's it even legal to demolish a crime scene when the person hasn't even been through their trial yet? So I don't know what the rules are about that, but I know that both the prosecution and the defense were okay with it. They felt like they got everything that they needed. But I do feel like at some point, and I can't remember when, the defense had come back and made a statement. Well, if the house hadn't been demolished, blah, blah, blah. I don't remember why they did that, unless it had something to do with the third party accomplice, whatever. So, I don't know, but pretty crappy, in my opinion. Hold on. I think this ends. Yeah, okay. So, yeah. They were going to come back after lunch, I think, and have their little meeting, but it was going to be a closed hearing. I think they were going to go over more jury selection stuff, but they wanted it to be not publicized, that part of the hearing. So, hey, Morgana Banana. I think they took it down too soon, too. Because, right, Aurelia? Such a ridiculous move. Because who here, raise your hand in the chat if you would be like, want to take a jury view. Now, I know that the venue is not in the same spot. It's not in the same county. But still, they could take a day trip and go do a jury view of this house. Right? I would want to see the house if I were a juror. Anytime and the reason why is because, one, you can't get sound things through photos. You know, because there's so much back and forth about, oh, well, Dylan said she could hear what sounded like Kaylee playing with the dog upstairs, right? And then you have Dylan saying that she could hear crying from one of the bathrooms or something. I mean, just different. And then you hear she heard, you know, there's you can't hear those things from photos. Now, I know that they also said people would say, well, but you can't hear those things inside the house either because the furniture was taken out of the house. I get that. But you're still going to get a better, I don't know. I just feel like that was a really stupid move. We were all telling the prosecution, bad idea. Exactly. And it does suck. Everybody's raising their hands, right? Miss King says exactly. The judge was even saying there were motions about it not being to scale. How are they going to put a full house in the court? I mean, and to be honest, what's this 3D house going to do for them? You know? I heard that they're going to have like a sort of like a virtual tour of the house, which you can do that online, right? Even right now, you can go back and find videos of where they've done virtual tours through the King Road the house. But Cherie said a friend of mine was saying that they're trying to hide something. Well, I mean, I don't know. I know that the defense or the prosecution feel like they got everything that they needed. They got, you know, a lot of crime scene photos and stuff, but you just don't know. I I don't think that it should have been torn down until after the trial was over, and I think most people feel that way. So, anyone who's lived in a house for any amount of time knows what sounds are strange, right? There's certain things like that you're not going to get from a photo or from a video view on a screen, you know? I remember one of the jurors said specifically, I think it was the Murdaugh trial, because they went on a view of the property at Moselle in the Alex Murdaugh trial. And one of the jurors said specifically that, I think I read this or heard this somewhere, and I don't remember where. Someone can correct me if I'm wrong, but I thought that I heard one of the jurors had said something like they knew something, that they had made up their mind about something pretty important because they were able to see specifically at, I think it had something to do with the size of the room, the like feed room where they kept the like dog food. Because the son was in, I forget the boy's name, was in that feed room whenever he was shot. And there was something specific, something to do with that, the space of that room and how he was shot and found, that the juror said, one of the jurors had said specifically that it was because they were able to see the actual stand, like there and see the actual room, that they made up their mind about something pretty important. And so that tells me the same could be said for this case, you know, to get a real bird's eye view of it. I don't know. But anyway, some important things that we learned today from Judge Hippler. I'm glad that we streamed this instead. I know that it was boring, you know, but I'm glad that we watched this today versus the Reed trial, because, you know, we're getting closer to this trial. So they're going to begin jury selection the end of July, and trial opening statements should begin August 11th. I have to write those dates down again. I wrote them down somewhere, but then I think I accidentally threw that piece of paper away. Okay. Jury selection, end of July, but I can't remember exactly. And then August 11 opening statements. So that's 3 months. Less than 3 months from now. Wow. All right. Defense will be obnoxious, right? Spins, there is, in a couple of the Discord groups that we're in, but it's hard for me to kind of get in there and find what I need when I need it, you know? Patricia, me too. I'm glad this judge put his foot down. Yep, he does. I like that about him. Like you said, very no nonsense. Very no nonsense. But court will be from approximately 8:45 to 3:30 p.m. each day, And that is in Idaho time, I think. Ay, ay, ay. Somebody remind me. I don't know what time zone they're in. I think they're 2 or 3 hours behind Eastern. So that would be potentially 12 to, I don't know. I'll have to play it by ear. And then no trial on October the 2nd and 3rd. And then he listed a few other dates. I can't remember. 2 or 3 other dates because of them being holidays. He says, unless at that point in time they are sequestered. If they end up being sequestered at that point in time, they may go ahead and have court on those days since they're going to be sequestered at that point. If they are. And he did also say if they end up being sequestered, the days may go longer. So instead of ending at 3:30, they'll end, a little bit longer later. And he mentioned the stream view. The trial will be streamed like what we've seen in all the other previous hearings through like the court's streaming system versus one of the big networks. No, do they have 2 times? I don't think so. I don't know. Spins, I'm just saying I don't know I don't know what time zone they're in Idaho. And it may depend because some states have 2 different time zones. It just depends on where they're split. But I don't know what time zone Idaho is in. Can anybody tell me? Let me go look. Idaho time zone. All right, so they're in Mountain Daylight. Oh, wait, here we go. Idaho is one of just 13 states that is split into 2 different time zones. It says, in the case of Idaho, part of Idaho is in Mountain Time and the other part is in Pacific. And I can't remember which county this is going to be in. Is it Ada? I don't remember. Oh, here, let me see. Aurelia says Pacific and Mountain. Yeah. Yeah. Pacific and Mountain, it says. Let me look real quick. It's in Ada County, Patricia? Okay. So let me look them up specifically. Oh, wow, I just saw Joe Don Baker, James Bond star, dies at 89. Ah, wow. Wow. Sad, sad, sad. What time zone is Ada County? All right, so it's saying Ada County is in Mountain Daylight Time. So they would be 2 hours behind me. So that means if they start at, what did it say, 8:45, we'll say 9 o'clock just to make it easy. So they would start court at 11 and end about 5:30 each day, Eastern time. So that's decent. That's good. I can deal with that. They tend to have shorter days when they're longer trials, which I appreciate. But anyway, oh, let me see. I hope so too, Laura. I feel like it will be. I feel like it has to be. But, you know, the same could have been said for Casey Anthony. I go back to that every time. Every time I'm like, oh, yeah, she's going to be found guilty, plain and simple. Poof. Right? All right, you guys, I'm super excited. It's going to be less than 3 months away before this starts. Now, they did say, too, that jury selection will not be streamed, so we won't get to see the jury selection process. Sometimes these trials, they'll let you see it, and sometimes they won't. So we apparently don't get to see the jury selection portion of the trial, but opening statements, like he said, is planned to begin on August 11th. So, May. Yeah, it's May, June, July. 3 months from now. It's going to fly by. It'll be here before we know it, right? Right, Patricia. That means we won't get to hear cheesy eggs a million times. Boo. Or if you come inside the courthouse and it was dry and sunny, but then when you leave and everything's wet and people have umbrellas, we can assume, right, that it rained. All of those funny little things they always go through every time. Chegs. Hashtag Chegs. Cheesy eggs. Oh my God. I love that. I love that a lot. Mm. All right. Well, you guys, thanks for joining me. Thanks for hopping aboard the Kohberger train today versus Karen Reed. And if for those of you that are mad at me for not streaming Karen Reed today, I'm sorry. I'm so sorry. I couldn't do it. Not with this going on. So, trademark Chegs. Chegs trademarked, right, Morgana? I love that. I love it. All right. So again, reminder, I will not be streaming tomorrow because Kiddo has 2 doctor's appointments. So I will not be streaming. Aurelia says, thank you. Sorry, was working at the same time, and I'm all for the Kohberger trial stuff. Yeah, I know. I'm all for it, too. Bubbles, or Cherie says, I'll take a change anytime. Yeah. Okay, yeah. Thanks, Patricia. Yeah. You guys have a great weekend, too. But, yeah. I don't know what we're going to do over the weekend. I don't know. I'm not sure. But I'm having a bit of a brain fart. I was going to say something and forgot what it was. I forget what it was. Oh, are we supposed to get some, Morgana? You mean over the weekend? I think we're supposed to get a lot of nasty weather. Naturally. Oh, I remember what I was going to say. Let me do a poll real quick while you guys are in here. Hold on. Let me do a poll real quick. Don't you guys leave yet. Hold on. I have to open up the stream and do... Wait, can I do it from my phone? I might be able to do it from my phone. Hold on. Let me see real quick. Although my phone is about to croak. No, I can't do it from my phone. Shoot. Okay. Then I'll do it from my computer. Hold on. Oh, while I'm thinking about it, click that thumbs up button before you leave. Yo. All right. Start a poll. Okay, I'm going to ask you guys a quick question in the poll. I think the vast majority of you are members over here. So, hold on. Hold on. Where did it go? Okay, here it is. Hold on. Just a minute. All right. Margaret's running around. Hold on. I'm working on a poll, Margaret, that you get to vote on this time. But you can only vote once, not 52 times. Uh, 85. No, you won't. Hold on. I'm working on some options here. Hold on, folks. I'm giving options here. I'm trying to think of good options. But you don't know what the poll question is yet. I'm keeping you hopping. Hold on. Hold on. I'm still working on these options. Trying to think what's going to work. Hold on. Okay, I'm just going to leave these options because I know what's going to work best for me. Okay. Close that out. All right. So, before I start this poll, I'll tell you real quick what my plan is. So, Spence says insert some Jeopardy music here. Da 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 da. No heat, no humidity, please. Our AC is out. Oof. No thanks. That would suck. All right. So what I'm thinking about is doing a like a Kohberger members only stream, where I'm going to try to do like some bits and baubles from the Dateline special, okay? From the Kohberger Dateline thing. I don't think that we would be able to watch the whole thing together. I'm not sure exactly. So, yeah. I'm not sure exactly. But anyway, this is the poll that I'm going to give you guys. So I'm starting the poll now. And for those of you that are members that want to do that, let me know what dates and times work best. Days and times works best. And that's for this weekend only. Not like every weekend. This is just for this week only. This weekend only. So hopefully that will I'll leave this up for a little bit so that you guys can vote. And if you're not a member and you want to be, let me pin that instead of show it there, because if I pin it, it'll be easy for you to find. Nope, I can't pin it from here. Maybe I can pin it from my phone. StreamYard lets you do some things and not other things. It drives me crazy. It drives me crazy. Like no one else. Boo, boo, doo. Pin. There we go. All right. Nope, that's not the one I wanted. I pinned Patricia's "so glad this judge puts his foot down" comment. That's not the one I wanted to pin. I want to pin crap. This comment. How to unpin it. Okay, now let me. Here we go. Pin that one. Now, the pinned comment, that link should take you to the memberships options if you want to join the membership. Any level. But yeah. Margaret says, leave it up. I'm almost done voting 195 times. You lie bag. Patricia says, I see all you night owls in the poll. Well, the only options for the poll for this one is going to be Friday night or Saturday night. Just letting y'all pick the time. But, you know, maybe dodging storms tomorrow evening. We'll have to see. Scatty, scatty, scatty. Very sketty. I don't like that. I don't like it. So far, 60% of you have said Friday night at 10 p.m. Eastern. Live from the closet under the stairs, right? Susan said, I'm here whenever you're live. Awesome. Well, I would just really love to do like a members only where I can like stream part of the Dateline special is what I would like to do. So Spin says I turn into a pumpkin at that time. A Friday night at 10 p.m. You sure you don't turn into a pumpkin at midnight? Yeah, right, Morgana. She does not. She don't turn into no pumpkin at 10 o'clock. Morgana. Uh-oh. Oh, no. Oh, not lately. This infection's kicking your butt. I'm sorry. I know that's tough. That sucks. That sucks. Now I got that song stuck in my head. All right, so we're still right around I think we're going to go with the 10 p.m. Eastern on Friday night, which is tomorrow night, 10 p.m. Eastern. Morgana's in timeout. Uh-oh. Margaret, 1-800-Morgana is mean, 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 mean. Anybody watch Days of Our Lives and remember Kristen's... I forget the girl's name. I forget the chick's name. But it's EJ's mom. And she always had the big buck teeth and had a big thing for Marlena. Susan Banks. Yes, Spins. That Stefano, he's just main, main, main. Or that Kate. That Kate, she's just main, main, main. Main, main, main. I love Days of Our Lives. I haven't watched it in forever. But anyway. All right. So I think the votes are done. We are at 50% for 10 p.m. So let me write that down. And as long as the Lord is willing and the creek don't rise due to bunches and bunches of rain and storms, we will do a members only live stream tomorrow night at 10 p.m. For Kohberger stuff. I'm here for it. I've got a little bit of a sort of a collection of different articles and different videos that I've seen that have had some pretty good information that I wanted to share. But definitely I want to look at that Dateline special too and talk about the things that they brought up in that Dateline special, because there was some big bombshells that they made in that Dateline. I'm not even kidding. I mean, some stuff that I was like, wait, what? Things that nobody's heard before. pretty crazy. Spin says Days of Our Lives is not worth watching anymore. Yeah, I know. No more John and Marlena's love story. That broke my heart. That broke my heart. No more story time. Morgana. That was the best. Your mom is spicy. Morgana's mom is great, you guys. Morgana's mom read us a book in the mod chat the other day. Yesterday. Last night? Is that what it was? It last night? And yeah. I'll let Morgana tell you what the book title was, because I can't. God. Morgana's mom is the best. She's the best. Mm-mm-mm. I'll let you tell him, Morgana. If you're not comfortable with it, then just say, nah. Oh, well, there you go. Yeah. That was the book that Morgana's mother read to us in the mod chat. Yeah. Wow. Yeah, Patricia. No, not. Yeah. And she read it to us like the librarian from elementary school, right? She was sitting in a chair. She had her leg crossed. And now that, mind you, Morgana's mother retired as a first grade school teacher for 41 years. Okay? So she's read a book or two to a few first graders. It was literally about cleaning a beaver, the animal. It was. That's what the pictures were of, was of the furry, the animal. But, you guys, it was hilarious. I can't with her. That was the cutest thing. All right, you guys. Well, let me write this down. I done forgot to write it down because I got over here discombobulated about the book. Patricia, it was hilarious. It was hilarious. No, it was a live one. I mean, it was a little illustrated book. Jeez. Okay. Membersonly.com. I'm kidding. Members only. Friday. 10 p.m. Eastern. All right. So I will have, I'll get a link ready for you guys. And didn't she do a commercial one time for a shower curtain or something? Yes, Brenda, it was a shower head. It was a shower head, yes. One of those big round or square shower heads that's like the rain kind of fancy shower head. Yeah, she did a little commercial for us with that too. Yeah, Margaret, we were all sitting around in a semicircle listening to it. She's so funny. Lord Morgana. I can't. Jeez. hmm. Anyway, what I was going to say is I will schedule the stream, the members only stream, but depending on what I can figure out about the Dateline thing, yeah. What I might do is start the stream and then give you guys a different link to go to, so that it's not actually on YouTube, if you know what I'm saying. I don't know. We'll have to figure it out, play it by ear. But I'm excited for it. So I'm excited for it. Her mom is a hoot, Patricia. She cracks me up. That's what she just said. Well, I ain't reading it. I'm not reading it. Oh my God. Oh. All right. Well, you guys have a great night. All right. I love you, and I will see you. Well, I'll see the members in the members only tomorrow night at 10 p.m. Eastern. And for the rest of you, I will see you back on Monday. I don't know what we'll be doing. I don't know if we'll get back over to Karen Reed or what. I don't know. If Proctor is on the stand, for sure, right? I don't know. Margaret said she voted 215 times. No, you didn't. It says we have 6 votes, ma'am. Let me end the poll, by the way. End the poll. Yep. Friday night, 10 p.m. 50% of the votes. All right, y'all. Love you too, Brenda. All right. Thanks for hanging out today. Make sure to hit that thumbs up before you leave. Subscribe if you are new. Click that notification bell and hashtag replay in the comments down below under the video if you're watching this on the replay. It crashed because I voted 220 times. No. No, it didn't. Thank you, though, for trying to vote that many times. I'll see you guys later. Have a great weekend. Bye.